One of my clients was about to buy a home with his new wife. It was a second marriage for both of them, and they each had children from their first marriages. They agreed to split the home 50-50. But here's the twist. They weren't contributing equally to the down payment. Right before closing, he called me and said, "How should we title this?" It sounds like a simple question, but here's the scary truth. The wrong answer could mean his kids get nothing if he passes away first. His wife could update her estate plan, or life could take an unexpected turn, and suddenly the inheritance meant for his children might never reach them. And this isn't just a one-off case. If you're in a second marriage, have a blended family, or are buying a home with unequal contributions, this is something you can't afford to overlook. In this video, I'm going to walk you through the 5 most common ways to title a home, and how each one can protect or completely unravel your estate plan, your family, and your peace of mind. Here's the thing most people don't realize. When you buy a home in a second marriage, titling isn't just about whose names go on the deed. It's about your legacy. It's about protecting your spouse and your kids. It's about making sure your money, your intentions, and your relationships are honored when you're no longer around to explain what you meant to do. Because the truth is, not all ownership types are created equal, and the one you choose can either preserve peace or guarantee conflict. The problem is, most people treat titling like a formality. You sign at closing, move in, and never think about it again. But when you're in a blended family, especially if one person contributed more, it's not just a formality. It determines who owns what, who inherits what happens if one of you passes away, and how fair or unfair things feel to everyone involved. And let's be honest, life changes. People remarry, families grow apart, estate plans get lost, updated, or ignored. If you don't structure this carefully now, your intentions can easily get lost later on. That's why it's so important to get clarity now, before life makes those decisions for you. If you are blending families, contributing unevenly, or just want to be sure your home passes exactly as you intend, let's talk. Book an estate clarity meeting to create a titling strategy that protects everyone you love. Link is in the description. Let's talk about your options, because there are several ways to title a home, and each comes with trade-offs. Join tenants with right of survivorship. This is probably the most common form of ownership for married couples. Each spouse owns 50%, regardless of how much they actually contributed. When one spouse passes away, the other automatically inherits the entire property. It skips probate at first death, which is great. But here's the risk. If you pass away first, your spouse becomes the sole owner, and they can change the beneficiary plan however they want. That could mean leaving the house to their own children, to a future spouse, or unintentionally dying without any plan at all, sending it right back into probate. In other words, your kids may never see a penny from your share of the home, even if that wasn't the intention. And there is limited asset protection here too. If one of the spouses has creditors, they may be able to go after that spouse's share of the property. Tenants in common. This option lets you each own a distinct percentage of the property. You can split it 50-50 if that feels fair, or reflect different contributions like 60-40 or 80-20. With tenants in common, your share does not automatically go to your spouse when you pass. Instead, it goes to whoever you name in your will or trust. That's a huge benefit if your goal is to leave your share to your children or preserve inheritance lines. But there are some downsides. If your share isn't held in a trust, it will go through probate. Also, each owner technically has the right to sell their share without the other's permission, something you can address with a co-ownership agreement. And if one spouse contributed significantly more money, this is where a post-nuptial agreement can be helpful. It's not about distrust. It's about documenting contributions fairly and making sure everyone feels respected. Tenants by their entirety. This is available only to married couples in certain states and only for your primary residence. It functions like joint tenants with right of survivorship, with the surviving spouse automatically receiving full ownership, but it adds a layer of protection. Creditors can go after the home for debts owed by just one spouse. It's great if you're concerned about lawsuits or liability, but it has the same issue as joint tenants with right of survivorship. If you pass away first, the surviving spouse inherits everything, and your children might be left out. So it's protective from the outside, but not necessarily from within the family. Community property. In some states, like California, Texas, and Arizona, any property acquired during the marriage is automatically considered 50-50 community property, regardless of who paid what. This system can offer tax advantages, like a full step-up in basis at first death, which helps reduce capital gains taxes if the home is sold later. But here in Illinois, we follow equitable distribution rules, not community property. That means titling and contributions matter more, and you have to be intentional about how you structure ownership to get the results you want. Now, this is where it gets really interesting and strategic. If your goal is to care for your spouse, but still ensure your kids inherit your share, a revocable living trust is a powerful solution. Here's how it works. You and your spouse title the home as tenants in common. Then, each of you creates your own revocable living trust and transfers your 50% share into it. That way, your share doesn't go through probate. It goes exactly where you want it to. You can even structure the trust to allow your spouse to live in the home for life, but not sell it or change the ultimate beneficiary. When they pass, your share goes to your children, just as you intended. And that's not all. If one or both of you become incapacitated, a revocable living trust allows a successor trustee to step in and manage the property without the need for court intervention or guardianship proceedings. You maintain control even after you're gone. And in the process, you avoid probate, minimize family conflict, and reduce legal costs and delays. Plus, in states with estate tax, like Illinois, where the exemption is only $4 million compared to $13.99 million at the federal level, a revocable living trust can be structured to reduce or even eliminate state estate taxes. For higher net worth couples, this may involve trust provisions like credit shelter trusts or AB trusts to maximize tax efficiency and protect more of your legacy. There is one more tool worth mentioning, a transfer on death instrument. Let's say you want to keep things simple. You use joint tenants with right of survivorship now and want your home to pass to your children after both of you pass. A transfer on death instrument allows you to name beneficiaries for your home, so it passes without probate. But here's the catch. The surviving spouse can revoke or change it. So while it's useful, it's not locked in. If your goal is to guarantee where your share goes, a transfer on death instrument alone is not enough. Before you decide how to title your home, you need to get clear on what really matters to you. Ask yourself, who do you want to inherit your share? Your spouse or your children? Do you want your spouse to have full control or just the right to live there? Did you contribute uneven amounts? If so, do you want that reflected? Do you already have trusts in place or need to create them? Do you want to avoid probate? Do you need protection from lawsuits or creditors? These aren't just legal questions, they are family questions. Your answers will determine which option makes the most sense. And let's be honest, mistakes here can be costly. Your kids may be disinherited, even if that was never your plan. The home could end up in probate, draining time and money from your estate. A surviving spouse might be forced to sell the house just to split assets with heirs they barely know, or worse, end up in court fighting your children. The inheritance plan you thought was locked in could be changed or undone. And what's left? Legal battles, broken trust, and family resentment that can last for generations. So what's the right option? It really depends on your goals. In my client's case, they went with joint tenants with right of survivorship with equal ownership. Before they got married, they faced a challenging period and supported each other through it. That experience built a strong foundation of trust, so for them, choosing survivorship felt right. But your situation might be different. If your top priority is simplicity and you trust your spouse fully to honor your wishes, then joint tenants with right of survivorship combined with transfer on death instrument may be a workable solution. But if your goal is to ensure your children inherit your share without uncertainty or risk, then the combination of tenants in common and revocable living trusts is a far better option. It avoids probate, it protects both your legacy and your spouse, and most importantly, it preserves family harmony. Titling your home isn't just a closing day detail, it's the foundation of your estate plan. If you're in a second marriage with kids from prior relationships and different contributions toward the home, this decision is critical. Do it right and protect everyone you love. Do it wrong and your intentions could be lost forever. The good news, with the right structure in place, you don't have to choose between your spouse and your children. you can protect both. And if you're wondering whether you should put your home into your trust, check this video where I share the biggest mistakes people make when funding their trust. Thanks for watching.